Welcome to the Breach of Contract lecture as part of the Law of Contract 2 course at the University of the West Indies Faculty of Law. Here's an overview of the topics we're going to cover as part of the Breach of Contract lecture. First, there'll be a brief introduction, and then we will look at the three main types of breaches: breach of a condition, breach of a warranty, and breach of an innominate term. We'll then move on to the fourth type of breach, which is a special kind of breach, which is called anticipatory breach. We'll also have a look at the issue of partial or defective performance. Lastly, I will summarize all the salient points. What is breach of contract? To understand that, we need to look at the whole idea of discharge of a contract. That means the different ways in which a contract can come to an end. The most obvious and the most common way is through performance. The respective parties perform whatever they promised, and once they've done that, such as handing over the goods and in return handing over the money, each party has rendered performance and the contract is discharged. Of course, in some situations, for instance where sales of goods are concerned, one of the parties, usually the seller, may continue to have obligations under a contract, such as a one-year guarantee on the goods sold. Another way a contract can come to an end is through breach. If one of the parties breaches the contract, this may allow the other party to terminate the contract immediately. However, whether that is possible or not depends very much on the type of breach. And in large part, this is what the current lecture is about. Third, a contract can always be terminated or discharged by way of agreement. This means that the parties to a contract may agree to an additional contract which serves to dissolve the previous contract. In other words, a contract to end another contract. Lastly, there are also other doctrines of contract law, such as frustration or mistake, which may lead to the discharge of a contract. We cover these topics in other lectures as part of the Contract 2 course. However, this lecture is on breach of contract. In its most basic form, a breach of contract is a failure to perform an obligation under a contract. Breaches can occur after or when performance is due, and when this occurs, a breach may amount to a breach of a condition, a breach of a warranty, or a breach of an innominate term. There's also a separate category of breach, which is breach before performance is due. This is called anticipatory breach. We will now move on and take a closer look at, first of all, the three types of breach that may occur after or when performance is due, and the one type of breach which may occur before performance is due. Let's start by looking at breach of a condition. A condition was succinctly defined in Suisse Atlantique, a 1967 case. There the court said that a condition is a stipulation which the parties have agreed, either expressly or by necessary implication, or which the general law regards as a condition, which goes to the root of the contract, so that any breach of that term may at once, and without further reference to the facts and circumstances, be regarded by the innocent party as a fundamental breach. In Poussard and Spires and Pond, the court held that a breach of a condition means that the breach goes to the root of the matter. It is about the essence of the contract. It is a fundamental term of the contract. In law, it is very often useful to compare cases and to look at these issues from the perspective of two cases that we can juxtapose. When we look at what a condition is, Poussard is a great case to juxtapose to another case called Bettini and Guy. In Poussard, Mrs. Poussard had contracted with Spires and Pond, who ran an opera, to perform in their opera for a period of 3 months. Unfortunately, shortly before performances were to commence, Mrs. Poussard fell ill. Spires and Pond had a backup singer in place, and the backup singer took over for the first 3 nights of performances while Mrs. Poussard was ill. On the 4th night, Mrs. Poussard returned and wanted to take her part in the opera. But by that point, Spires and Pond had terminated her contract. She claimed for wrongful dismissal. The court held that since turning up for the first few performances was essential, was very important to the contract, Spires and Pond were entitled to rescind the contract. In other words, the breach by Mrs. Poussard went to the root of the matter. In contrast, in Bettini and Guy, the singer was Mr. Bettini, and he had contracted with Mr. Guy to sing at the Royal Italian Opera in London. Again, the contract was for a period of about 3 months. The contract also stipulated that Mr. Bettini had to attend rehearsals. However, Mr. Bettini did not attend rehearsals. He was, however, available for the actual performances. Guy tried to terminate the contract, and so Bettini sued. In this case, in contrast to Poussard, the court held that the clause that Bettini had to attend rehearsals was not a condition. It did not go to the root of the matter. It was not a fundamental term. This is really a great illustration of what it takes for a clause, for a term to be a condition. In Poussard, missing actual performances meant breach of a condition. In Bettini and Guy, only missing rehearsals did not mean breach of a condition. Incidentally, in Bettini and Guy, the court held that had the original clause, namely the clause that mandated that Mr. Bettini had to attend rehearsals, had that clause spoken about the right to terminate in clear words, for instance, had it said that Mr. Bettini must attend rehearsals, and if he does not attend rehearsals, this may be seen as grounds for termination. Had the contract stated that, the court would have accepted those words as agreed between the two parties. In other words, in that event, the clause in Bettini and Guy would have amounted to a condition. But the contract did not say that. The contract only said that Mr. Bettini had to attend rehearsals. And on the evidence, the court felt that this was not a breach of a condition. It was not strong enough. It did not go into the essence of the contract. It was not fundamental enough in order to be a breach of a condition. Now, this is very important because, as we shall see, in order for the parties to be able to rely on what they agreed on as being a condition, if that is what their true intention was, it is important that the parties stipulate not only that something is important or that someone has to do something under the contract, but also stipulate that if this does not occur, if there's a breach, then this may be taken by the innocent party as a reason to terminate. So you really need to come at this from both sides. Now remember, this is 1876, and some of the subsequent cases show us that the courts have consistently looked at it the same way. That means, for a condition to be enforced as such, the best way to achieve that is for the parties to state very clearly in their contract not only that the term that they've agreed on is important, that it is fundamental, but also what happens when there's a breach. And if what happens is the right to terminate, then the court will agree with the parties as they have agreed that this is in fact a condition. So when a term is deemed to be a condition, there's really two things we know. First of all, we know that for it to be a condition, it must go to the root of the matter. Secondly, we know that it being a condition, any breach entitles the innocent party to terminate the contract altogether. Since Boussard and since Bettini, the courts have had many opportunities to expand and to clarify on the rules relating to what a condition is. In Hong Kong Fur Shipping, a case that we will come back to later, the court held that breach of a condition relieves the party not in default of further performance of his obligations. So, it's what we saw earlier. A condition is not only a very essential, a fundamental term of a contract, it also entails that any breach of it may lead to termination of the contract. However, as the courts clarified in Schuller and Wickman, just calling something a condition does not mean that it is a condition. As we already found out, the best way to go about it when you draft a contract is to mention that something is a condition as well as mentioning what happens when there's a breach, namely termination. In Schuller and Wickman, Schuller, who manufactured presses that were used by car manufacturers, hired Wickman to try and sell those presses to car manufacturers. It was agreed that Wickman should send out its representatives to visit car manufacturers in the United Kingdom at least once every week, and there were 6 car manufacturers, so that would have amounted to 6 visits per week. It was also said that this clause was a condition, so the word condition was expressly used here. The court held that even though use of the word condition is strong evidence of the intention that it is a condition, the facts of the case suggested otherwise. For instance, in terms of the representatives who were supposed to visit the car manufacturers, there was only 2 representatives that were named. The contract made no stipulation for what if one of the representatives died, got ill, or in other way had to be substituted. Also, given the huge amounts of visits that were required under the contract, for the duration of the contract it amounted to 1,400 visits. The court held that the parties must have envisaged that perhaps not all of those visits would take place as agreed. In the event, Wickman did not perform some of the visits as promised. Schuller terminated the contract, and Wickman sued, alleging that Schuller was not allowed to terminate the contract. So it essentially all came down to whether the word condition, which was used in the contract, immediately and automatically amounted to a condition. That means a fundamental term which allows the innocent party to terminate, or whether, even though the word condition was mentioned in their contract between Schuller and Wickman, it may not necessarily amount to that. In the end, for the reasons I mentioned, as well as a few others, the House of Lords concluded that this was in fact something less than a condition, and Schuller was not entitled to terminate the contract. So we learn that if parties use the word condition, that is strong evidence of their intention, but it is not conclusive evidence. However, where parties are clear as to their intentions, the principle of certainty of contracts prevails, and the courts will enforce what the parties have in fact agreed as evidenced in their contract. In Lombard, North Central, and Butterworth, Butterworth had leased a computer from Lombard, North Central. Payment was to be made by installments, and it was a term of the contract where the payment was not punctual. This was a breach of a condition, and allowed the innocent party to terminate.